Hello, my name is Ira Smith, president of Ira SmithTrustee and Receiver Inc. Now you see I'm wearing a tie today. It's not because I was in bankruptcy court, because the courts are closed down, and it's not because I'm having a special meeting face-to-face with anyone. Ira SmithTrustee and Receiver Inc. is fully operational, and Brandon Smith and myself are available to answer any questions you might have by telephone or video call, but we're not seeing anyone face to face. No, the reason I'm wearing a tie today is because a good friend of mine, Mark Borkowski of Mercantile Mergers and Acquisitions, has been very supportive ever since I started doing the face on camera video of Brandon's blog rather than just a voiceover. But the one constructive criticism that he has is I should dress up a little more and wear a tie. So Mark, this one's for you. Now, I hope you'll be able to watch the video until the end because I know you will get value from it. It will be especially valuable for anyone that is in the construction business, who advises anyone in the construction business. You're a subcontractor, a general contractor, or a builder. It's a recent decision of the Ontario Court of Appeal that is very helpful in setting out the lay of the land for certain types of construction liens in an insolvency proceeding. So, hang in, I will be right back. I'm just going to get rid of my tie now. Now, today's Brandon's blog that he wrote about is a very interesting, recently released decision of the Ontario Court of Appeal. The case was heard in the fall of 2019, and in March of 2020, just before the courts shut down because of the state of emergency, the decision was released. And it has to do with the area of construction law and the Construction Act. Now that is a whole specialty unto itself, and lawyers spend an entire career dealing only in that area of law, and we're not lawyers and we don't profess to be experts, but of course in insolvency proceedings, in doing receivership or bankruptcy or restructuring of companies where there is construction projects, we become quite familiar with the workings of the Construction Lien Act, as it used to be called. Now it's the Construction Act in Ontario. So this decision in the Urbancorp matter is very interesting. Urbancorp was a developer, builder of residential condominiums that ran into trouble. And whenever you're in the insolvency of a construction situation, there's always competing interests. There's the subcontractors, the general contractor, those that supplied materials to the site. There's the secured creditors who have advanced construction funding. And then the licensed insolvency trustee has to get involved in the middle as referee to try to sort it all out. And more often than not, there are court proceedings in order to help resolve issues. Now, before getting into the case, I just have to go over some basic background. There are essentially four kinds of insolvency proceedings. One is a restructuring, a corporate restructuring to try to avoid bankruptcy, and that can be done under either the restructuring proposal provisions of the Bankruptcy and Insolvency Act, or for bigger cases under the Companies Creditors Arrangement Act. It is also possible under those statutes, under the restructuring provisions statutes, to also do a sale of the assets. Then there is an out-and-out bankruptcy under the pure bankruptcy provisions of the BIA, and Then there's also a secured creditor enforcement action, either secured creditor privately appointing a receiver under its security to take possession of the assets, develop a plan, sell off the assets, obtain the cash, pay the cash over to the secured creditor. Or the secured creditor can go make application to court, say that it is just or convenient for a receiver to be appointed to sort out the mess, and then the court appoints the receiver, and the receiver comes back to court with a plan of action, gets approval, goes off, and then markets and sells the assets, all with court approval. In the Urbancorp case, it started off as a notice of intention to make a proposal under the restructuring provisions of the Bankruptcy and Insolvency Act, BIA, and then ultimately the court converted it to proceedings under the Companies Creditors Arrangement Act, CCAA. And it is under that act that the proceedings continued. As is normal, a licensed insolvency trustee was appointed as monitor. The monitor got all its approvals from the court, including how to sell the assets, how to market them, and then who to sell them to and for how much money. Got all that approved, and then the court approved the monitor holding on to the cash in lieu of the assets that were sold. Subcontractors were making claims that they had a valid construction lien, a valid trust claim against the assets, the cash the monitor was holding on to. So the monitor made application to court to get this all cleared up to see if there was or wasn't a valid trust claim. The lower court held, based on the analysis of the evidence and analysis of cases, including a former Court of Appeal decision, that there was not a valid trust against the funds the monitor was holding. The subcontractors appealed this decision. And as part of this appeal, they also raised the constitutional question of, does a provincial trust still survive in an insolvency proceeding under a federal insolvency statute? Or put another way, does the federal law trump, small t, the provincial law, and therefore this is known as the whole topic of paramountcy. Is the federal law paramount to the provincial law? So the court first had to look at the constitutional issue. They looked at it only in the context of this case, and the specific section of the Construction Lien Act is Section 9, where it states that when an owner sells its property, a valid trust claim arises under provincial law for those that have added value to the lands. So the court first considered, in the context of this case, can a provincial legislated trust survive under federal insolvency legislation? And after a very thoughtful and deep analysis, the Court of Appeal's answer was yes. A provincially created trust under the Construction Lien Act could survive if the necessary elements are there. It then looked at the elements of the case, a very detailed analysis. Again, I'm not going to go through all the details. I will just highlight it for you and summarize it for you and say that this is what the court looked at. Now, remember at the beginning, I talked about there's essentially 4 kinds of insolvency proceedings. The court mentioned those and looked at that. And they differentiated this case, being a monitor under restructuring proceedings, from other insolvency cases where it's a trustee in bankruptcy or a receiver-manager selling the assets. Because in the case of a trustee in bankruptcy in a pure bankruptcy administration, or a receiver-manager in a receivership administration, The licensed insolvency trustee is not selling the actual assets. The licensed insolvency trustee is actually selling its right, title, and interest, if any, in the assets. So the receiver does not take ownership, or the trustee in bankruptcy does not take ownership of the assets and then sell them. The section that these subcontractors of the Construction Lien Act were going under is Section 9, that starts off by saying where an owner sells the assets of the owner. Now, in a restructuring proceeding, either under the BIA or the CCAA, the monitor is not becoming the owner of the assets, and the monitor has absolutely no interest in the assets. What the monitor is a representative or an agent of the owner, and it is in that capacity that the monitor in the Urbancorp case sold the assets. So the first thing that the court had to look at was it the owner selling the owner's assets? And because the monitor was acting on behalf of the owner, the court said yes. So Section 9 applies. It then had to look at, did the owner have any value, any equity? And what the court looks at is, what are the proceeds? What are the mortgages registered against those assets that were sold? After that, is there any money left over, or is there a shortfall to the mortgagee secured creditor? In this case, there was money left over. So because it was the owner selling its assets, and because there was money after any mortgages registered against the property being sold, the court determined that the subcontractors had a valid trust claim against the proceeds received by the monitor as agent for the owner, and the Court of Appeal then reversed the lower court decision and held that the trust claimants were entitled to share in $3.9 million pro rata based on their individual claims. And that is what the court decided. This decision will be very helpful to insolvency practitioners, advisors to the trades, advisors to construction companies, subcontractors, and the builders. So I hope you've enjoyed this video. Feel free to read the entire blog. It goes into much more detail. And if you have any questions at all about this video, this blog, or any questions at all, you can shoot myself or Brandon a message, or you can call either of us up. We'd love to hear from you. Stay healthy, take care of yourselves. We hope you and your families are safe and healthy.